Part 2, Chapter 4, Employment Law. So we're going to start again, pick up where we left off with the American privacy. Okay, so the Bill of Rights safeguards American freedom and privacy. An individual's privacy is not absolute. If an employer can show their need to know is greater than an employee's right to privacy, invasion of privacy is warranted. The employer's need to know must be job related. Okay? So next we'll look at the Privacy Act of 1974. This was enacted to safeguard private info of federal employees by the feds. So, no information about an employee may be released before obtaining prior written consent. That's with your background checks, anything you fill out. If you pay attention, you'll notice you always sign a form saying that you can give consent for them to conduct a background check, and they usually send you a copy in the mail or to your email. Okay, so that's not something new. Employee information must be kept in a secure place to guard against unauthorized access. Again, this is people's social security numbers, private information. If you're going to have people in and out of the office, you've got to have it in a locked, secure place. I was an HR manager with a staffing agency, employment agency, and we had a client which allowed us to have a on-site office. And all of our employees would, come into the office or the site office to speak with their with me and basically, talk about their time, if they're coming in late, sick kid, whatever. Well, it was so much traffic that we actually had to have a separate filing cabinet in a closet so that people wouldn't have access to things laying on desks or up on the computer monitor, etc., etc. Okay? So you got to go above and beyond to protect people's privacy. It's important. Private sector employee access to personal files is not guaranteed. Okay? I think this is particularly interesting. Workplace privacy and your expectation of privacy is interesting. So I'm going to talk about that a little bit too. But we're going to get into electronic type privacies. So phone conversations. Employee conversations can be recorded. They must be job related. And the employer can't listen to the entire conversation. So they can't sit there and just eavesdrop on your conversation. But if it's work related, they can listen to that. The Electronic Communication Privacy Act of 1986 covers people's privacies to email. And the expectation of privacy to email. If email is on a company computer, the employer can read it. Which means if you have email on your job computer, and you have, let's say you work for the state and you've got a state email address, the state can use and access and look through that email because it's theirs and you're just using it. You shouldn't have an expectation of privacy on anything that the state provides or the job provides to you. That's your phone, your email, anything that you have your information on that they give you is their property. So keep that in mind for everyone. Anybody that is employed, if you're an employer or if you're a worker, you should know that. Okay, so that pretty much covers privacy. There was one more piece I wanted to discuss about privacy, and that is talking about the expectation. So there is a clause, or I should say the supporting feature of the Privacy Act is that you are allowed to have, or I should say, if you have a expectation of privacy in your office or your space that everyone doesn't have access to, and they go through it, you can argue an expectation of privacy. That's your desk, that's your locker maybe, unless they have it someplace explicitly posted saying don't expect, privacy in a locker. But I would say probably your desk. Your desk and your filing cabinets are big ones that they bring up, and they mention that People have been working with the company for years, senior management. They even gave an example in the book about I think it was a physician that had an expectation of privacy in his office, and the employer went through his stuff, and he actually won because he had that expectation. All right, so that concludes privacy. The next section we will discuss will be credit checks and the Fair Credit Reporting Act.